Good afternoon, everyone. Welcome to this, our third annual guest lecture. My name is Danga Kamau. I'm the registrar of the Lcia Miac Arbitration Center. This is our first, I think, gathering in the Mauritian legal community since the ICA Congress in May. And I hope for those of you who were there, you've spent the time since then, the 6 months since then, working your contacts and really kind of developing your arbitration practices and interacting with the practitioners that you met at the time. This afternoon is our second event of today. We had a question and answer session this morning with Judith Gill, QC, and a group of young practitioners where they had the opportunity to ask questions of Judith about her career, about prospective careers in international arbitration for themselves. And it was quite a fruitful discussion, and indeed it overran, and I think the young practitioners who were there can say they learned a few things, one of which was the changing landscape of international arbitration and how it's changed since Judith was a young associate herself in London. And staying on this theme of changes, I think one of the things that we have to be very conscious of in Mauritius is that the international arbitration landscape is growing and changing quite fast. We have seen development of international arbitration centers, and in India has proclaimed it wants to become a center of international arbitration. Just yesterday there was an announcement that there's a new center in the British Virgin Islands, another in Jamaica. So what we realize from this is that we can't rest on our laurels. We know that in Mauritius we've done a lot of work to develop a law, we have a modern arbitration law, we've developed institutions, but that in itself is not enough. It's a necessary but not a sufficient condition for the success of the jurisdiction. Something more needs to be done, and what that is has to be done by all of us, not just by LCI Miac, but by practitioners, by the government, by potential users. We all have to come together and have a coordinated approach because success of this jurisdiction is not inevitable. Some of the things that we can do is it would be nice to see more Mauritian lawyers participating in arbitration conferences in mainland Africa. We've had a request for that. I get asked often, where are the Mauritian lawyers? And I say there are many of them and they're active and interested, but people want to see you actively participating in these forums. We can also have gatherings where we discuss topical issues, because as this jurisdiction becomes a notable jurisdiction in international arbitration, so too must we be a center where issues of national and international importance in international arbitration are discussed. And that's why we're here. This, as I said, is the third annual LCI Miac Users Council guest lecture. We've had 3 before, and I see some familiar faces from last year's lecture. And really the idea of these lectures is to bring in an international arbitration expert who can share their perspectives on a topic that's of importance around the world, but also that should be of importance, and I believe is in Mauritius. So we're blessed, really, to have Judith Gill, QC, here with us, not only because of her expertise, which Thierry Koenig will outline for you, but because she's also the president of the LCIA Court, which, as you know, the LCI is a joint venture partner with the government of Mauritius to form LCI Miac. And this is her first visit to Mauritius, so she's had an opportunity to see what is this wondrous thing, Mauritius, that we all speak of. And I believe she's going to be able to go away with quite an interesting perspective to share with other LCI board members. So with that, I will hand over to Thierry Koenig, who is the president of the LCI Users Council, which I encourage all of you to join if you haven't already, and he will introduce Judith. Thierry, thank you.
Thank you, Nagda. On behalf of the Lcia Miac User Council, I'm delighted to welcome you all. I'm privileged to introduce Judith Gill, QC. Mrs. Gill read law in Oxford. She is a solicitor advocate, the first of 2 women who were attributed to QC, and she is the first QC for international arbitration. Mrs. Gill is a partner of the firm Allen & Overy, which needs no introduction. She has been author of numerous articles on arbitration, which I recommend you to read. It's a very interesting reading. She is the president, as Nagla just said, of Lciac, and as you know, Lciac is the authority regulation which helps Lcia Miac in the administration of the rules here. She needs no introduction. She is regarded as a Band 1 Chambers lawyer. She is regarded as one of the international stars, both as counsel and as arbitrator. In much further ado, I will leave the floor to Judith. Thank you.
Thank you very much for that wonderful introduction. I hope I can live up to it. Good afternoon, everyone. It's a great pleasure, great honour to be here to speak to you this afternoon. And thank you very much to the Users' Council for inviting me. So my lecture this afternoon is going to look at the question of conflicts of interest in arbitration proceedings. This isn't a new topic, but it's one which is evolving and which regularly presents fresh dilemmas and controversies for arbitration lawyers and lawyers generally to discuss. And why should that be? Well, thinking about this, I identified a number of potential reasons. I think the first, and perhaps most obvious, is the availability nowadays of information about potential conflicts. One suspects that in the past there may well have been certain connections, affiliations with a company or its related entities, which may have gone unnoticed. But in this day and age, of course, we all have access to the internet, to information, and that accessibility, I think, has probably been, in part at least, the explanation for the increase in challenges based on conflicts of interest. It may be anecdotal, but I think there is also an increased willingness to challenge arbitrators, and that in turn, of course, leads to more reported decisions, more rulings from arbitral bodies, and that then promotes discussion and debate. It's difficult to get accurate statistics, but I think it's also widely accepted that the volume of arbitrations taking place across the world has been increasing with the globalization of international trade, and that has not necessarily been matched by a similar increase in the pool of available arbitrators. So you've got a bigger volume of arbitrations, but perhaps not the same growth in the number of arbitrators, perhaps making conflicts a little more likely. But one of the main reasons, I think, for the challenges that this topic presents is the fact that it's very difficult to articulate and apply clear rules which will give you a determinative answer readily accessible and available to all in each case. Rather, they tend to turn on their own facts. And when assessing those conflicts, of course, one has to bear in mind the complexities of modern life. And there was one quote that I particularly liked from a tribunal in an ICSID case which had been asked to determine a challenge. And as they put it, arbitrators are not disembodied spirits dwelling on Mars who descend to Earth to arbitrate a case and then immediately return to their Martian retreat to await the call for the next arbitration. Like other professionals living and working in the world, arbitrators have a variety of complex connections with all sorts of persons and institutions. And I think that in some ways sums up the nature of the problem. We are not isolated islands. We have complex relationships. But it's precisely those connections and relationships that may give rise to concerns about conflicts of interest. So this afternoon, I'm going to look at this under essentially the four topics, to start by looking at common situations where conflicts can arise, how they affect international arbitrations. And I'm then going to look at how they're identified and dealt with under national laws and institutional rules, which is essentially the tools that we primarily look to. But I'm then going to move on and talk about the IBA guidelines on conflicts of interest in international arbitration, because this represents, in my view at least, a fairly landmark attempt by the arbitration community to provide applicable standards and practical guidance to practitioners in the field in order to help them deal with conflicts. They are a valuable reference point for arbitrators and for counsel and even for courts, although, as we'll see, they have their limitations. But to my mind, this subject really comes to life when you start looking at real examples, because reasonable people can hold different views on a number of the sorts of issues that arise in connection with conflicts. And that makes the topic interesting, but it makes some of the judgment calls that are required, both of a challenged arbitrator, of a party considering a challenge, and indeed of whoever has to decide that challenge, more difficult. So I'm going to look, as we go through, at a number of cases that have been decided, particularly by the English courts with which I'm perhaps most familiar, but also some of the practical situations that I've encountered both through the LCIA and also in the course of my practice. So let's start with a few introductory remarks on conflicts of interest. It's a fundamental principle of international arbitration that arbitrators must be independent and impartial. And independence is generally seen as an objective question, a fact concerning relationships between the arbitrator and the parties, counsel, and indeed potentially other arbitrators. Is there independence or a relationship of dependence? On the other hand, impartiality is connected with actual or apparent bias and is therefore more subjective and a rather more abstract concept. But the two are very much related, indeed inextricably linked in many ways, because a lack of independence will almost always give rise to doubts about impartiality of an arbitrator. Now, it's worth noting, conflicts of interest are not, of course, the only grounds for challenge and disqualification of arbitrators. They might be challenged because they fail to satisfy any necessary qualifications, or because of an inability or unwillingness to act, or their actions in the course of a case might give rise to doubts about their impartiality. And that can be what they do before or at, or indeed after a hearing. But in this talk, I'm going to focus very much on challenges to arbitrators which are based on the existence of an alleged conflict of interest. So why is the potential for a conflict of interest considered to be of such importance? Well, to my mind, it's because conflicts potentially undermine the integrity of the arbitration process as an objectively fair dispute resolution mechanism. And as a result, they can undermine the confidence of the users in the system, without whom, frankly, there is no arbitration. It's the users who need to have confidence in the procedure that they're adopting. And one of the greatest benefits of arbitration is often perceived to be, in addition to the enforceability of awards, the ability to choose a neutral forum and to have the dispute resolved by independent and impartial decision makers. And that's particularly important in international transactions, which is why arbitration has become so popular in that context. The home jurisdictions of the parties may not be considered suitable by the other party. They may have a poorly trained or biased or even corrupt judiciary. Or there may simply be a concern about hometown advantage and neither wants to go to the other's courts. So one of the key attractions is the ability for neutral, independent and impartial decision makers. And against that background, it's easy to see why conflicts of interest can have a broader implication than simply the outcome of any one dispute. They have the potential to damage the legitimacy of the process of international arbitration. And the imperative to avoid conflicts of interest leading to this result can actually override other key principles of arbitration, such as party autonomy, and particularly the right of a party to select their own chosen arbitrators. But of course, conflicts aren't confined to arbitration. They're just as significant in the context of domestic court proceedings. Basic principles of due process and natural justice require that no one can be a judge in their own cause. But arbitration has particular features which arguably make conflicts of interest more likely and potentially more damaging when they do arise. For example, the point I've put up here, judges are usually regulated and subject to discipline and oversight as part of a formal judicial system. But in most arbitration systems, any natural person can be chosen to act as an arbitrator. They may not even be required to hold any legal qualifications or otherwise to meet any objective standard of suitability or experience. One would hope if you have an arbitrator appointed by an institution or confirmed by an institution, then some form of standard would usually be required. But in principle, a party can nominate whom they like as an arbitrator, and there's no independent verification or regulation of their suitability. Unlike many judges, or most judges I would suggest, arbitrators often continue to act as counsel in other cases, and that can give rise to a range of potential conflicts. The arbitration community is actually relatively small, and the relationships that develop, both positive and negative, can sometimes be influential. Particularly in smaller jurisdictions, an arbitrator will often find himself or herself appearing before or against or sitting on panels alongside the same colleagues again and again. Even in a relatively large legal market like London, I recall appearing as counsel before an arbitrator, only to find that just a few days later we swapped roles and she appeared before me as counsel while I was sitting as arbitrator. Does that matter? In most cases, probably not. But what if the cases were somehow related? Perhaps less clear. What if the party in both cases that she represented and I represented was the same? One can see these relationships have to be viewed in their broader context. The confidentiality of arbitration can also make conflicts of interest more difficult to identify. As I say, more information is available, particularly about external relationships, but not so much about private arbitrations. That raises its head in the context of recurrent appointments of the same arbitrator by a party over and again, and I'll come back and talk some more about that. But what this means is that there's greater reliance upon the arbitrator to actually make the disclosure. And finally, perhaps, why is it important? Well, in the court system, there will usually be a right of appeal. In arbitration, in many jurisdictions, there is no right of appeal. So a decision made by an arbitrator with a conflict of interest on the merits of a case will be binding unless and until that conflict comes to light and a successful challenge is mounted. It's not, if you will, a part of the ordinary process that it can be corrected on an appeal. Let's look broadly at the types of conflict of interest. I would put them in two main categories, and one can argue, no doubt, about categorization, but essentially I see them as relationship conflicts and issue conflicts. Relationship conflicts include where the arbitrator has some personal interest in the outcome of the dispute or has had some previous involvement in it. They may also arise where the arbitrator has a relationship with one of the parties or its counsel, and such relationships may be entirely unobjectionable and arise simply as a course of normal consequence of professional life. But that won't always be the case, and in essence, it's relatively easy to identify potential situations of conflict of interest, but actually determining whether a particular set of facts gives rise to a situation where the arbitrator should step down or be removed is rather more difficult. As I say, human relationships are often complex, and it is virtually impossible to come up with a comprehensive set of mechanical rules to be applied. So we have grey areas where we have to look at the particular facts. That's relationships. The other area is issue conflicts. That might arise, for example, if an arbitrator is called upon to determine a particular point of law, may be arguing that same point as counsel in another case. And an example of this arose in a case called Telecom Malaysia and Ghana, a challenge which was brought before the Dutch courts against a well-known French arbitrator. And at the same time as sitting as an arbitrator in that case, he was counsel to another party in a case which involved similar legal issues. And to demonstrate my point that reasonable people can differ on these issues, the challenge was rejected both by the two fellow arbitrators, to whom it fell first to decide, and also by the Secretariat of the PCA. But the Dutch court came to a different conclusion, and they adopted a rather pragmatic solution of telling the arbitrator that he had 10 days to resign from the counsel role, failing which he would be removed as arbitrator. But that issue conflict is a real one that could be faced when an individual acts as both arbitrator and counsel. Issue conflict can also arise where it's suggested that the arbitrator has prejudged the issues in dispute, for example, by giving a previous opinion on the merits of the dispute which is being arbitrated. Now, whether this is grounds for disqualification will depend on the circumstances. However, as I'll discuss in a minute, the mere fact that the arbitrator has expressed a general view on some legal issue is not going to be sufficient for him or her to be removed. There must be some additional reason to believe that the arbitrator is incapable of approaching the issue with an open mind. Now, I've just put up here some of the examples of the identity conflicts. The situations range from the obvious, such as where the arbitrator has a direct and substantial financial interest in the outcome of the dispute. But these types of conflict also cover the more controversial, where, for example, the arbitrator's law firm, but not the arbitrator themselves, have acted for one of the parties in an unrelated matter. And again, just to put some flesh on the bones of how the particular facts can affect a ruling, a situation where an arbitrator owns 100% of the shares in a party to the arbitration would clearly be unacceptable. But what if it's 10% or 0.1%? What if the company is publicly listed and this is just part of a much broader portfolio held by the arbitrator? What if the shares are held through a trust? Where exactly do you draw the line? When you're considering commercial or family or social relationships, again, one has to look at the nature and the quality of the relationship. But potentially there's a very broad network of relationships that might be relevant between the parties, employees and officers of the parties, counsel, co-arbitrators, and anyone else who might have an interest in the outcome of the dispute, such as insurers, for example. Now, some of you may be thinking, after what I've said, that it sounds as though potential conflicts arise at every turn. Well, there are some situations which I think many people would agree on as being what I might call safe, as not giving rise to conflict of interest. Personal attributes, for example, such as race and religion, do not of themselves give rise to concerns about independence and impartiality. But in a recent case in Australia, for example, one of the parties sought to challenge the 3 members of the tribunal, which consisted of 2 Australians and 1 Englishman, on the basis of their shared cultural heritage, namely they were all part of the British Commonwealth. The court gave that very little time and pretty short shrift, but the mere fact that a challenge would be made makes one reflect, are matters ever truly safe? But I think in broad terms, one can treat those attributes as really not relevant in the context of conflicts. Quick word on nationality. Generally, that is also the case for nationality, but there are, of course, some restrictions in various sets of institutional rules, including the LCIA rules, regarding nationality of sole or presiding arbitrators, and other rules, such as the ICSID rules, are even more restrictive, so one does need to just be alive to that. But other safe situations would include insignificant shareholdings in public companies. Professional relationships per se would not ordinarily give rise to a conflict, and indeed they're probably largely unavoidable in many jurisdictions. Previously expressed legal opinions not relating to the particular case are generally safe. An arbitrator, like a judge, will naturally approach the issues with a fully formed view of the world and a set of predispositions. But as long as he can keep an open mind, that's not a matter of concern. Indeed, in the arbitration context, the fact that a party can select an arbitrator with a particular background or outlook or cultural approach may be a specific reason why they would want to pursue arbitration. So how do we know where we do cross the lines if these are mostly safe? When are they not? Well, let's look at some examples. And I will tell you the answers, but I'm going to put the questions up first so you can consider them and form your own view, whether you would have reached the same conclusion. So the first example, again, this is a real situation. The presiding arbitrator of the tribunal didn't have a direct financial interest in the dispute, but he was a non-executive director and shareholder of a competitor of one of the parties. And that competitor was an unsuccessful bidder for the agreement which was the subject of the arbitration. So, was there a conflict? Well, in this case, the English court held that it wasn't a conflict of interest. They took into account the relatively small size of the arbitrator's shareholding, the fact that he had no role in the management of the competitor, and that he offered to resign as a non-executive director as soon as the issue was raised. As I say, each case turns on its own merits, and it might have been different here, for example, if he had been involved actively in the management of the competitor company, or perhaps if his shareholding had been rather more significant. Let's look at another example. This one relates to recurrent appointments. Now, this is an issue because in many jurisdictions, and I suspect Mauritius is one of them, the pool of experienced and well-known arbitrators is relatively small. And we often see law firms acting for different clients, but appointing the same arbitrators again and again. And that may be unavoidable or simply reflect the experience and ability of the arbitrator. But it can be problematic. So when do recurrent appointments become a problem in terms of the appearance, at least, of impartiality? Well, of course, what the arbitrator has to say on the issue may not be terribly informative. Most arbitrators would consider themselves professionals who would never be swayed by the prospect of future appointments. But for the parties involved, they may view things rather differently. In this case, the appointing authority appointed a sole arbitrator after taking into account the views of the parties. But it transpired that this particular arbitrator had acted in 25 other cases involving the respondent, who were a construction claims consultant. 25 in the past 3 years. And he had derived 25% of his total income during that period from these appointments. Well, was that a conflict of interest? Well, in that case, the High Court said that there was a conflict of interest, giving rise to justifiable doubts about his impartiality. But it's not simply the factors I mentioned. They also took into account the fact that he had failed to disclose these other appointments, and when information was sought on them, he responded in an aggressive and hostile way to the party who was seeking to raise questions about these other cases. And it was also relevant, the court found, that the respondent, which as a claims consultant was involved in many arbitrations, both as a party and as a representative, had a practice of manipulating the appointment process by completing the relevant forms so as to steer the appointing authority away from certain arbitrators and towards its preferred arbitrators, and they also maintained a form of blacklist to whom they would object. So they were treading a very fine line in terms of the way that they, as a party, approached the appointment of arbitrators. And all of these factors weighed in the court's decision. I think the final example for now, at least, concerns prior representation. In this case, the arbitrator had recently appeared as counsel in a completely separate case, but with one of the parties was the same in each. And in that other case, the arbitrator, then as counsel, was involved in making allegations of dishonesty against the party concerned in the context of document production. So again, was it a conflict? And the answer was again, yes, there was a conflict of interest, indicated by the serious nature of the allegations made by the arbitrator, the fact that the same solicitors were acting for the party in both the previous case and the present case, and the fact that only 7 months had passed since the events complained of. And in case anyone was thinking that this is a slightly peculiar one-off situation, I actually encountered a very similar set of circumstances where an arbitrator was successfully challenged for having recently, in his counsel role, but in another matter, having levelled allegations of professional misconduct against a lawyer acting for one of the parties in a case where he was now arbitrator. And again, he was successfully challenged, largely, I think, on the basis of the nature of the allegations that had been made. But the key point to take away from these different examples, I think, is that decisions on conflicts of interest are often highly fact-specific. And if you tweak the facts, you could get a rather different result. So in that last example, if it hadn't been 7 months since the counsel had appeared on the other side of the party and made those allegations regarding disclosure, if it had been 7 years, would the result have been the same? Perhaps not. And in the second example, but for the wrongdoing of the claims consultant in trying to manipulate the process, would the court have come to the same decision? Well, maybe, maybe not. What they did arguably didn't impact the number of cases, the proportion of cases, or indeed the proportion of income that the arbitrator made. But the court, looking at it, looked at these issues in the round. So when should we be considering questions of conflict? Well, the answer is they can arise at pretty well every stage of the arbitration process. Before it gets started, parties must consider potential conflicts when they decide to nominate someone as an arbitrator. The arbitrators themselves have a duty to consider whether there are potential conflicts which would preclude them accepting appointment, and they must disclose facts that might reasonably be of concern to the parties. And in my experience, when issues are raised at the outset of a case, the arbitrator will very often voluntarily decline appointment. And in many ways that makes sense. Why press a controversial appointment in circumstances where you're right at the outset of a case, you can avoid unnecessary time and costs being spent on a potential challenge, and another candidate can be chosen. But again, one shouldn't underestimate that a party may well feel that they have been done out of their right to have their chosen arbitrator as a member of the panel as a result of a dubious challenge, even in these circumstances. As the arbitration progresses, again, if facts come to light that indicate a potential conflict, again, this can be raised in the course of the arbitration. But as we'll see, many of the applicable rules and laws preclude a party just sitting on their hands in relation to a challenge, requiring instead that once they become aware of facts that might give rise to a challenge, they have to get on and pursue their complaint rather than simply waiting to see, for example, what the outcome of the arbitration is and only deciding to challenge if they need to, if they have been unsuccessful. That is widely frowned on and resisted by the relevant rules. Assuming that an arbitration is ongoing, the circumstances alleged to give rise to a challenge will usually be raised first with the arbitrator, him or herself, and alternatively with the relevant institution, if there is one. And if the arbitrator considers that no conflict exists and refuses to resign, it's then going to need to be determined by reference either to the applicable arbitration rules, either institutional rules or UNCITRAL rules, for example, in ad hoc cases, or by reference to the national law which is applicable, which will almost always be the law of the seat of the arbitration. And then finally, of course, an award which is tainted by a conflict of interest, which perhaps hasn't become apparent until after the award has been made, that may be set aside or refused enforcement. Now, just as an aside, I would mention the question of who determines any challenges that are made. And the answer to that will depend upon the applicable arbitration rules and or relevant national law. As I say, if you're applying a national law, usually going to the courts would mean going to the courts at the law of the seat, who would apply their own law to the issue. But if you're dealing with a challenge through an institution, the answer of who decides it will not always be the same. Under some arbitration rules, such as those of the LCIA, the institution itself, through a division of its court, will decide the challenge. In ICC cases, the ICC court will determine any challenges under its rules. But other rules, including in particular the ICSID rules, provide instead that where, for example, there's a challenge of one arbitrator on a panel of 3, the other 2 arbitrators are required to resolve the challenge. And of course, even if a challenge is resolved through the processes of the institution, it may well then subsequently be subject to review by a judge in a national court, as we saw in the Dutch case that I mentioned earlier. At this point, it's perhaps just worth stepping back a little bit and reflecting on the potential for abuse with challenges to arbitrators. One has several competing interests at play here. As I've said, genuine conflicts of interest undermine the integrity of the arbitral process and of course must be discouraged. But historically, there's always been something of a constraint on unmeritorious challenges, because clearly a party doesn't want to make a challenge which is then unsuccessful and be left with an arbitrator who has the added baggage, perceived or real, of potential resentment at the challenge having been mounted. And that, I suspect, over the years has often served as a restraining influence. But increasingly, and perhaps especially in treaty cases, there are concerns that challenges to arbitrators are increasingly being used for tactical purposes, and that unmeritorious challenges are being used as a mechanism to delay or derail arbitration. And those are the types of different interests that one needs to balance. These competing considerations need to be all put into the mix when deciding how to deal with challenges. So, with those broad comments, let's move on to look briefly at how this complex and difficult subject has been tackled, and we can take a look at some of the standards that have been imposed relating to conflicts of interest in an effort to deal with the issue. As always, with arbitration, if you are under the auspices of a particular institution, you need to look at what those particular rules say. You need to look at what the particular national law says. But one can see that there are some similarities in terms of the approach taken. The standards which are applied to determine whether or not there is indeed a legitimate cause for concern against the arbitrator will come from these different sources, but many of them do establish general norms or standards for identifying potential conflicts. And again, the approach is to look at general standards rather than a mechanistic solution that can be automatically applied to each and every fact circumstance that arises. And many national laws in particular incorporate the concept of reasonable or justifiable doubts regarding the independence or impartiality of the tribunal. And the English Arbitration Act, for example, refers to circumstances that exist that give rise to justifiable doubts as to the arbitrator's impartiality. And this wording imposes an objective test. And as most of you in the room will know even better than I do, similarly in Mauritius, under your International Arbitration Act 2008, again, the test is circumstances that give rise to justifiable doubts as to the arbitrator's impartiality or independence. The institutional rules, again, one can see similar tests applied. The Lcia Miac rules, circumstances that give rise to justifiable doubts as to his impartiality or independence. And this is a consistent approach with other leading institutional rules, although you'll notice that the ICC rules are perhaps slightly less explicit, and the phrase "or otherwise" in particular is often seen as giving the ICC really a very broad remit in terms of determining challenges. Justifiable doubts, what do we mean by that? Well, in England, they arise where the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. That's how the test is actually applied. And over time, that's been somewhat refined. The characteristics of the fair-minded and informed observer are such that he's not a lawyer, but he is someone who is assumed to know all the facts and to be aware of the way in which the legal profession operates. It's someone who reserves judgment until they've seen and fully understood both sides of the argument, and someone who has a balanced approach and appreciates the context. So it's not someone who is overly sensitive, as indeed a challenging party may be, but it is an objective assessment. Under the New York Convention, as I mentioned earlier, conflicts of interests can also provide grounds for setting aside or resisting enforcement of an arbitral award. If it hasn't come to light until after the award has been made, it may still be possible to actually challenge the award on the basis that the composition of the tribunal was defective or recognition would be contrary to public policy, both of which are grounds for refusing recognition under the New York Convention. But one of the key aspects in actually dealing with conflicts of interest is this notion of disclosure by the arbitrator. And the arbitrator is the person best placed to identify potential conflicts of interest. And that's why decisions about disclosure are so important. It's, I think, well established that disclosure does not of itself imply the existence of a conflict. And in fact, an arbitrator who actually lacks confidence in their own impartiality should simply decline the appointment. But the purpose of the disclosure is to alert the parties to circumstances that the arbitrator considers might be relevant, not disqualifying, but might be relevant, and which the parties might wish to consider as potentially giving rise to matters that they want to explore further. And viewed in this light, disclosure is often actually as much about protection for the arbitrator and clearing the arbitrator to act as it is a basis for raising objections. The institutional rules often impose a specific obligation to disclose. The ICC rules, for example, require arbitrators to disclose in writing to the Secretariat any facts or circumstances which might be of such a nature as to call into question the arbitrator's independence in the eyes of the party, as well as circumstances giving rise to reasonable doubts. The Lcia and Miac rules similarly require a written resume of past and professional positions and also a written declaration stating whether there are any circumstances known to the arbitrator likely to give rise to any justifiable doubts about their impartiality. And some institutions, including the ICC and the LCIA, have a specific declaration form which arbitrators have to fill in which they confirm that they have made appropriate disclosures and are otherwise impartial. But ultimately, it is for each arbitrator to decide what it's appropriate for them to disclose. And that, of course, gives rise to concerns that they might not all approach it in exactly the same way. And I recall a tale from some years ago of a well-known arbitrator who was a partner in an international law firm who would complete a disclosure form by confirming that he personally had no conflict, but that he worked in a large firm with partners all over the world and couldn't be sure whether any of them had worked on related matters or not. In other words, he wasn't going to ask. That, I think, would not be acceptable in this day and age, and I suspect institutional appointments would not be given on the basis of that type of disclosure. There is a duty of inquiry. But the lack of a uniform approach to disclosure is also highlighted when dealing with American parties, because in the United States, the approach to disclosure is traditionally much more stringent than in Europe or other parts of the world. And the Federal Arbitration Act has been interpreted as including a strict duty of disclosure. And the issue can arise that you will have an arbitrator who is used to the American system and their strict disclosure, who will come up with a far longer list of potential matters which an arbitrator from another jurisdiction might not consider warrant disclosure at all. And equally, when you then transpose that to the parties from a jurisdiction where disclosure is considered to be necessarily widespread may have a different view of the adequacy of disclosure by another arbitrator. And I remember, for example, being approached to vouch for the conduct of a conference panel that I chaired, because one of the speakers on my panel was being questioned about his dealings with another panelist who subsequently appeared before him as an arbitrator. Now, that's a situation which most people, I think, would not feel gave rise to any need for disclosure or further discussion. Appearing on a panel together happens on a regular basis, but apparently it's not unusual for that to be explored further in the United States. So while disclosure is certainly the safest approach, you have to weigh the benefits of disclosure against the potential disadvantages of excessive disclosure. The parties may be encouraged to make unmeritorious challenges if over-enthusiastic disclosure is provided, and an institution may be reluctant to appoint someone with a long laundry list of disclosures, even if individually they don't amount to a great deal. Again, just as an extreme example, I've seen an arbitrator who, in their disclosure statement, this is an established academic, disclosing the fact that he had been a junior associate with one of the parties' counsel's law firm 30 years previously. But he thought fit to put that on the disclosure form. Perhaps unsurprisingly, as an institution, we took the rather pragmatic view that the fact that this was referred to in his CV was sufficient, and we didn't need to bring particular attention to it. So those are the national laws, arbitration rules, but I wanted to specifically mention also the efforts of the International Bar Association on conflicts of interest. And in 2004, a working group composed of arbitration practitioners from different jurisdictions and backgrounds around the world came together under a subcommittee of the International Bar Association and produced the guidelines on conflicts of interest with a view to ensuring a more prescriptive and consistent approach to dealing with conflicts. And this was by far from being the first attempt to do this, but in my view at least, it has been the most successful to date by some distance. At the outset, it's important to recognise what they are not. As the name suggests, they are guidelines. They are not law, and unless they're incorporated into the arbitration agreement, they do not bind the parties or arbitrators. They're a form of soft law in the sense that the provisions are widely accepted, and even if not binding, they've gained acceptance internationally as a workable set of principles and practical examples on the basis of which to determine whether or not a conflict exists and or whether disclosure is appropriate. And in my experience, both arbitrators and parties and their counsel regularly refer to these guidelines when deciding whether to nominate, whether to accept a challenge, or otherwise to make disclosure. And to that extent, I think they've had a considerable degree of express. In my own firm, for example, we will often circulate emails asking who's appointed this particular named individual in order to count up how many appointments in the last few years do we meet the IBA guidelines. There are two parts to the guidelines. I can run through them fairly quickly. Part 1 sets out general standards regarding impartiality and independence and disclosure, and there are 7 principles of general application. And Part 2 then goes on and lists a number of concrete factual situations which are categorised in a traffic light system of red, orange and green. So if we start with the general standards, this General Standard 1 sets out the overriding continuing obligation of impartiality and independence, consistent with the national laws and rules that we looked at. General Standard 2 deals with the situations where an arbitrator must refuse to act. So if they have any doubt subjectively as to their ability to be independent or impartial, then they should refuse to act. And secondly, there's an objective test. Arbitrator must refuse to act if facts or circumstances exist which, from the point of view of a reasonable third person having knowledge of the facts and circumstances, would give rise to justifiable doubts on impartiality. So again, this is largely reflecting the national laws and the arbitration rules that we've seen. The remaining 5 standards really expand on that general obligation. General Standard 3 requires disclosure of facts or circumstances that in the eyes of the parties give rise to doubts. Unlike General Standard 2, the reference to the eyes of the parties makes this partially at least a subjective test. And General Standard 3 also makes it clear that any doubts are to be resolved in favour of disclosure. So this presumption arguably represents an affirmative shift in approach, so that if in doubt, disclose. General Standard 4 is a time limit of 30 days to raise objections once you become aware of relevant facts, but it doesn't apply to the red list circumstances. General Standard 5 clarifies that the guidance applies to all types of arbitrators and administrative secretaries. The practice of having tribunal secretaries in arbitration is increasing. It's an excellent way for young practitioners to get exposure to the way in which arbitrations are conducted, but it does raise its own potential conflict issue, and therefore the standards include secretaries. General Standard 6 deals with the identity of the arbitrators and parties, and this is quite important to the extent that it's a principle of the guidelines that an arbitrator is considered to bear the identity of his or her law firm. And similarly, a director or manager of a corporate entity may be deemed to share the identity of that corporate entity. And then finally, General Standard 7 imposes certain other duties, including to disclose relationships and to conduct reasonable checks. So as a set of norms, they are general standards which provide useful guidance. but in my view at least, these would simply have joined the many other standards which are of largely academic interest but little practical application, had the IBA committee not gone on and introduced Part 2. And Part 2 is, as I say, what I think makes the real difference, because it consists of 4 categories of practical situations identified by the member of the committee, characterised into 4 groups. The non-waivable red list and the waivable red list, the top 2, contain situations which are considered as giving rise to justifiable doubts as to impartiality and independence. They must be disclosed, and ordinarily they would preclude an arbitrator from continuing. The exception is the waivable red list, the sort of second limb, if you will, of the red list, which can be expressly waived by the parties. Again, I've put up some examples of each, but within the IBA guidelines, you have a long list in each of these categories of the different situations that arise under them. The orange list is a non-exhaustive list of situations that, depending on the circumstances, may give rise to doubts, justifiable doubts as to impartiality. They don't automatically result in disqualification, but they do engage a presumptive obligation to make disclosure and inform the parties of the matters referred to. And any potential conflict will have been deemed waived if, following disclosure, no objection is made within the 30 days. And then finally, the green list is the list of objectively safe situations where no appearance and no actual conflict of interest is likely to exist. So the arbitrator need not make disclosure of matters on the green list. Now, the red and green list are intended to deal with the relatively easy situations at either end of the spectrum. The orange list, a rather longer list, is very much the grey area, and that is why it is and has to remain non-exhaustive. The guidelines were updated in 2014. They maintained the 2-part structure, but added a number of incremental changes designed to address particular situations that had arisen in the intervening 10 years. In particular, dealing with advance waivers, which are often used to shield the arbitrator from challenges if and when a conflict arises in the future. So particularly for someone who's in a law firm, they will seek an advance waiver. So they will accept the appointment, but they will seek effectively to have the parties agree to the fact that they are taking the appointment as arbitrator on the basis that their firm will not be precluded from acting on unrelated matters, provided they personally are not involved. The rules don't prohibit such waivers, but they note that their validity has to be assessed on a case-by-case basis, and the key issue there is whether or not there was truly informed consent, and they also don't discharge the obligation for ongoing disclosure. As I think we touched on earlier, in principle the guidelines make clear also in the revised version that the arbitrator is considered to bear the identity of his or her law firm. Barristers' chambers are not, however, to be equated with law firms under the guidelines, and no general standard is given in respect of chambers. And I'll come back to that shortly. Other changes included a new provision dealing with third-party funders and insurers who have a direct economic interest in or a duty to indemnify a party for the award to be rendered or the award to be rendered in the arbitration, and they are considered to have an identity with the party to the arbitration. So again, if the existence of the third-party funder means that there is a conflict of interest, then between the arbitrator and that funder, then that is now caught by the new rules. And I did just put up a few quick examples just to look at how these apply in practice. And just to illustrate to some extent how difficult and how fine some of these distinctions are, and where a view has had to be taken based on the collective input from the members of the committee. So if we look at some of these scenarios, the first, the arbitrator has reviewed standardised lease agreements for one of the parties over the last 5 years. He's charged a fixed fee of $1,000 for each review. The agreements are unrelated to the present dispute. I'm not going to ask for a show of hands, but you can form your own views whether you think they are green, orange, or one of the two versions of red. And perhaps a little surprisingly, the answer is this appears to fall within the orange list, namely that the arbitrator or his or her firm represents a party or an affiliate on a regular basis, but such representation does not concern the current dispute. It's also noteworthy the fact that it was a relatively small amount charged for each. If it was a significant part of the income, that could change to the red list. So if the law firm, even if the arbitrator himself isn't involved, was earning a substantial amount as a result of this work, that could easily change matters. Second scenario, where the arbitrator has previously given legal advice to one of the parties concerning its rights under a contract, and those rights are now disputed in the arbitration. That one's in the waivable red list. So, yes, on the face of it, a conflict, but it could be waived by the parties if they were inclined to do so. And again, just in case anyone is thinking that this is perhaps slightly unreal, who would want to have an arbitrator who had previously given advice in relation to the same matter? You might like to look at the Weisfish and Julius case, where a sole arbitrator had not just given advice, legal advice, to both of the parties in relation to the subject matter of the arbitration, he'd also acted as a mediator between them in the same dispute. But the parties nevertheless wanted him to then act as an arbitrator to resolve their difficulties. So these somewhat strange situations do happen. I should also mention as a footnote the LCIA Miac rules, which provide that no arbitrator, whether before or after appointment, shall advise any party on the merits or outcome of the dispute. So under those rules, it would not be allowed. Finally, my last scenario, the arbitrator has recently sat on another tribunal together with the general counsel of one of the parties. Well, that one is on the green list. The arbitrator and a manager, director or member of supervisory board have worked together as joint experts or in another professional capacity, including as arbitrators in the same case. So the mere fact of that would not make any difference. Let's look a little bit to the future. I turn to the final subject, and I appreciate we're moving on in time. I think as far as the IBA guidelines are concerned, I think they do give a real favour of where lines might be drawn. They're not perfect, but they are workable, and they do provide a practical yardstick for practitioners. We're already on the second iteration, and given the way that the IBA works, this will be a continuing process. I have no doubt of that. But they've not been entirely without criticism, generally well received, but in some cases there have been difficulties, and I would mention in particular this recent English case where the claimant challenged two awards on the basis that the sole arbitrator was a partner in a law firm in Canada, and that law firm did substantial work for one of the parties, for a related entity to the respondent. The arbitrator had done a conflict check. It hadn't thrown up this connection, and he made clear that had the connection been identified to him, he would have disclosed that fact, but he, interestingly, although he was a partner, he was not in a profit-sharing relationship with the firm. And the challenge was then dismissed, and the arbitration was, the arbitration awards were upheld. The court took the view that the IBA guidelines were useful, they were valuable in terms of their contribution, and he specifically acknowledged that, but equally felt that the way in which this particular issue was approached by the IBA guidelines was not one that he was prepared to follow. And he identified two core weaknesses. He said, first, the fact that justifiable doubts necessarily exist in a non-waivable red list is inconsistent with the more general requirement to consider the facts of any particular case. And he also considered that the relevant provision of the non-waivable red list was just too broadly drafted, that one needs to be able to look at those specific facts rather than just automatically determining that something is non-waivable, and in particular where you're talking about the arbitrator's relationship with his law firm. But as I say, I do think it's relevant that even though he disagreed with the IBA guidelines, the judge went to some length to explain why he disagreed and to confirm a broader sense that the guidelines do, as he put it, provide a valuable and appropriate basis for examining the situation, at least as a check, is how he put it. Another well-known issue, which I suspect is actually quite relevant in this jurisdiction as it is in my own in England, is the question of barristers and their position. The IBA guidelines left the position of barristers' chambers somewhat unresolved. They made clear they're not to be treated as or equated with law firms, and they don't provide a general standard, but they do acknowledge that disclosure may be warranted of some relationships among barristers as a result of their working together in chambers. So what happens in this situation? Well, again, I think from our perspective as English and Mauritian lawyers, we probably see the fact that that barristers from the same chambers is unlikely to raise any concerns. We're very familiar with it. We're used to it. These are sole practitioners, and even if they share administrative services, they don't share profits and they don't share confidential information. But the problem with this is that increasingly in different parts of the world, barristers' chambers are marketing themselves as a collective. They have chambers brochures. They market themselves through chambers events. And it's perhaps unsurprising, therefore, that increasingly parties will tend to equate barristers' chambers with the sort of corporate identity of a law firm. And therefore, that gives rise to potential expectations within parties which may need to be addressed. And that's really the second element. Many parties involved in international arbitration around the world, particularly if they come from legal cultures where there's a fused profession, will not feel comfortable or fully understand the way in which chambers operate. And in an international context, that can give rise to difficulty. And that's illustrated in many ways by the case with the unpronounceable name, which I shall refer to as the Slovenia case. And in that case, Slovenia identified the addition of a barrister to its legal team at a late stage in the proceedings, and he happened to be a member of the same London chambers as the presiding arbitrator. The arbitrator was in fact an arbitration member of chambers. He wasn't a practicing barrister, and the two of them did not know each other. But nevertheless, and somewhat controversially, the tribunal upheld the claimant's objections and ordered the barrister to withdraw from the case. And I say controversially because there was no express rule permitting the tribunal to make such an order, which obviously impaired the respondent's freedom to choose its own counsel, but the tribunal determined that it had power to make that order to exclude counsel to protect the status of the tribunal and the legitimacy and integrity of the proceedings. And they made clear that there's no hard and fast rule as far as barristers are concerned, that they either the fact that arbitrators and barristers are in the same chambers necessarily gives rise to a problem or necessarily doesn't give rise to a problem. But they did take into account the fact that the chambers system was quite foreign to the claimant and its counsel, and the fact that the appearance of the counsel was at a relatively late stage of the case. Finally, let me turn to just a few further short points, mention a few practical issues relating to conflicts and the future challenges that we faced. First of all, timing of challenges. I've mentioned briefly that many of the rules require conflicts to be raised as soon as they are the facts that give rise to them come to light. But that may not be until the enforcement stage. And one then has the conflict between wanting to preserve the integrity of the process by not enforcing an award of an arbitrator that was subject to a conflict of interest. But it shouldn't be underestimated how very disruptive it can be if, having gone through the entire process of an arbitration and got a resulting award, that is then challenged at the final hurdle, if you will. And in practice, one suspects that there may well be a natural tendency to be sceptical of challenges by an unsuccessful party which are unrelated to the merits of the claim, even if it's said that the information that's relevant was only found at a later stage. The second point I would touch on is third-party funders. I'm not sure they've really made their way to this jurisdiction yet, but I'm sure they'll be here. They are very, very widespread and popular in Australia and in the United States, and we are increasingly seeing them in other jurisdictions, and in particular Hong Kong and Singapore are both changing their legislation in order to accommodate third-party funding. This is a professional funder who provides the funds for a case in return for a share of any successful award. And as I mentioned earlier, the 2014 revision of the IBA guidelines went some way to addressing the need to deal with third-party funders, but it still left a number of open questions, not least the requirement to actually disclose the existence of third-party funding. And that's very important in the context of conflicts of interest, and it's one of the issues that much of the legislation is trying to tackle. That if the existence of a funder gives rise to a conflict of interest, because, for example, the arbitrator is himself or herself a counsel in a case that is funded by that same third-party funder, one needs a mechanism for that to be transparently addressed. And absent legislative provision in arbitration, you can often find yourself in situations where it's simply not aired. Third point I would just mention briefly is that there has been a move towards greater transparency in these decisions. There was in 2011 a volume of Arbitration International published with many anonymised LCIA decisions on challenges to arbitrators. We are hoping to produce another volume before too long because the first was very well received, but clearly it's a fairly major task to undertake. But the transparency trend is, I think, continuing. The ICC has been subject to some criticism because it has never given reasons for its decisions on challenges. That is now changing, and they are taking an approach that they will give reasons if requested. I think probably I ought to stop there because I think we're running out of time. But let me just say, I think in short where we are, I think we've come a long way in terms of dealing with conflicts, in terms of the the transparency of dealing with them, and in terms of providing both arbitrators and practitioners with tools to enable them to consider their position in an informed way. But perhaps inevitably, with the nature of the beast, we don't yet, and we probably never will have, a mechanical way of determining whether or not there is an objectionable conflict. But hopefully that will mean that we will have continued examples which will add to the debate going forward. Thank you very much. Yeah, absolutely. I'm very happy. I've put questions up. I'm very happy to take some questions if you'd like to. I think there's a microphone at the back if anyone stunned into silence. Yeah.
Yes, it's me again. Mrs. Gill, in light of the growing debate on conflict of interest with arbitrators, do you believe that the issue conflict and repeat nominations should be made part of hard law instead of just being part of the IBA guidelines? Do you think the IBA guidelines are sufficient to deal with conflict of interest?
I think that hard law, it's very, very difficult for hard law to actually deal with these situations in the similar way of providing concrete examples. I think one does need to retain a degree of flexibility, particularly within the national court system. I think having parameters such as the IBA's rules on 3 appointments within 3 years, for example, is helpful in many cases. But there is an issue in trying to make it overly prescriptive. Because, for example, you will have many particular types of arbitration, commodity arbitration, insurance arbitration, shipping arbitration, or perhaps arbitration within a relatively small community where, in practical terms, that is very, very difficult to apply and still have a workable system. The example that I put up there, the Kofi case, that was 25 appointments by the same arbitrator. Now, clearly that should have been disclosed. That's very, very different from what's provided for in the IBA guidelines. I think if you're talking about a broad sense of commercial cases, you can apply those sorts of numbers in a reasonably rigid way. But I think in terms of national laws, I think most national courts would not want to tie their hands in that way. So I think my own view, the short answer to your question is, my own view is, I think that actually the use of IBA guidelines as guidelines and their adoption and reference by courts around the world, including with criticism, which can then lead to the evolution of them, I think is actually a more positive and helpful way to go, rather than having different national systems incorporate as hard law what inevitably would be different perspectives on what is and is not appropriate.
Thank you.
There's another question.
Thank you. You've been talking essentially about commercial arbitration, but I would like to ask your views about the application of the principles you've just mentioned to interstate arbitration. Mauritius challenged the appointment of arbitrator in interstate arbitration under the UN Convention on the Law of the Sea. The UK appointed the British judge on the ICJ as its arbitrator. And the challenge was not based on the fact that he was also an ICJ judge, but on the fact that he had maintained his relationship with the foreign ministry in the UK after his appointment as an arbitrator. The tribunal unfortunately ruled against Mauritius, basically on the grounds that all the institutional rules and the rules under the various international conventions apply only to commercial arbitration and not to interstate arbitration. Yeah. So do you think that that we should in fact have the same rules for both. And in this particular case, if that was commercial arbitration, would there have been a finding of conflict or not? Thank you.
Well, to answer your final point first, I think the answer to that depends quite on the nature of the relationship, whether it was purely a professional working relationship with the Foreign Office or whether actually it was a much more personal relationship with the individuals involved. So again, one would need to look at the specifics. My own view and my practice tends to be both commercial arbitration but also increasingly investment treaty arbitration, which is obviously different from state to state. But again, you've got the issue of state parties involved with all of the public interest implications that brings with it. And although I think when I first encountered them, I found it a little bit strange, when you apply the ICSID rules, which is probably the most common body for investment treaty arbitrations, their nationality rules are written in a very convoluted way, but the upshot is that in an ordinary case where you've got three members of the tribunal, none of them will be the same nationality as either of the parties. So whereas in commercial arbitration, parties often see it as a real advantage that they can choose at least one of the three as of their own nationality, who will understand their own legal background and culture, who will effectively, without being biased, but will at least have a degree of cultural understanding of them and the way they are putting their case. In the investment treaty context, I think it's a very different approach that is adopted, and you really see, generally speaking, three neutrals. My own view is that that has a lot to commend it, particularly when you're talking about state parties to arbitrations. They are different cases. The public interest aspects bring a whole different dimension. And when these arbitration cases go wrong for a state, it is their public, their taxpayers that have to pay the bill. And I think therefore the essence of transparency and neutrality are, if anything, even more pressing in that context. So I can't pretend I can change the rules for you, but certainly my personal view is that in the context of arbitrations involving states, there's a lot to be said for an entirely neutral tribunal.
You just mentioned the active or otherwise the role of third-party funders. What gave rise to the creation of those weird creatures?
I suspect that depends who you ask. I think those who are in favour of third-party funding see them as an opportunity for claimants who are impecunious for whatever reason, including possibly the actions of the other party to the dispute. They are then provided with a means of funding a legitimate claim that they might not otherwise be able to bring. I think increasingly, at least as far as the funders maintain, the use of third-party funding has actually been extended to parties who are perfectly able to fund litigation, but who actually use third-party funding as a risk management tool. So in other words, if you are a large multinational corporation, do you want to invest your $3 million in taking the chance on an arbitration case, or will you enter into a third-party funding agreement so that the funder bears the majority of that risk, albeit that ultimately at the end of the day your return would be rather less. So those are the factors which are said to drive third-party funding. Of course, for the third-party funders themselves, they're about making a profit. They are commercial organisations, and they have investors, and their role is to make profits, which is in some ways a positive feature, because it does mean that they're not going to fund a a case which they believe to be unmeritorious and unlikely to succeed, because they will recognise that they'd simply be throwing their money away. People have different views on third-party funding. I think certainly my own view is that they are here to stay. I think they will become probably increasingly common as a risk management tool, but it is really important that we address the issues that arise as a result. That has started to happen. I don't think we're entirely there yet. I've got an example at the moment where, again, it's a treaty case. The claimants were funded. I acted for the respondent state. We succeeded in getting the claim dismissed. We got a costs order in the state's favour for several $1 million. We repeatedly asked the tribunal for assistance in trying to get security for costs, but because it's a treaty case, there is no automatic cost-shifting rules. The tribunal didn't want to know. So instead what you're left with is a successful state, a funded party, a party that, frankly, is unlikely to have much in the way of assets against which that order can be enforced. So that's the sort of situation which I'm not convinced we've really properly grappled with yet, but I hope we will.
I have a question about third-party funding, which, as you mentioned earlier, could have an impact on the independence of arbitrators. Consequently, do you think that arbitral institutions should include in their arbitration rules express rule on disclosure of third-party funding in order to avoid any conflict of interest?
I think that's certainly one approach that we may well see appearing. One of the things that's been very obvious in the last few years is the way that so many of the institutions have continued to evolve their rules. I was involved in the 2010 version of the Miac rules. I think we've had at least 2 more versions since then. ICC, LCIA, regular iterations coming out of their rules. I think it is possible that that will be added. At the moment, it's tended to be something which is being addressed in the context of legislation. For example, in Singapore, where I live at the moment, we are looking at legislation which will specifically allow third-party funding, which at the moment at least is prohibited by the rules on maintenance and championship. But that is being amended to allow for third-party funding and to deal with some of the issues. And one of the key issues is disclosure, because you can then leave it to the tribunal to decide what to do, and also, of course, to make sure that proper disclosure is made of conflicts. I think the concern is that unless there is an obligation to disclose, and it's an obligation with teeth, that may not happen, and that can give rise to real concerns. And so one of the approaches, for example, is to seek to restrict the recovery of costs if there's been a failure to disclose. That's one of the devices that's being looked at. I'm sure the institutions will continue to look at this field, and it wouldn't surprise me if it does become part of the arbitration rules, depending on, of course, where the national laws get to in dealing with the matter. I think our time is probably up, so thank you.
I'm afraid we have to stop there because Judith has to get to the airport without getting trapped in Port Louis traffic, which I'm getting quite nervous about. But I'd like to say thank you very much for joining us, and we hope, and giving us this lecture especially, and I hope this will not be the last of your visits to Mauritius. Secondly, I'd like to thank my team at the LCI Miac, Dipna Ganu in the back, and Smita Laksimon, who I think is outside. And finally, I'd like to thank you. We would be nothing without the arbitration community in Mauritius, and we hope you'll remain engaged, attending events, but also promoting the jurisdiction actively, not just in dispute resolution instances, but also when you're advising your clients in banking and insurance and other financial services. We will be launching new rules, as Judith has intimated, perhaps in the first quarter of next year, if all goes according to the schedule. So keep an eye on your inboxes. we'll be having a launch event around then. And finally, I welcome you to join us for some tea and coffee and other refreshments. Thank you very much.